Hi, I'm Amy Hamm with the New Westminster Times, here to give a summary of everything that's been going on with the notorious Cowichan decision. This week in Richmond, BC, more than 650 residents gathered for a public hearing on the August Supreme Court of BC ruling Cowichan v. Canada. This is a case that began back in 2014 when the Cowichan Nation initiated a lawsuit against defendants, the province of British Columbia, the city of Richmond, the Vancouver Fraser Port Authority, the Musqueam Indian Band, and the Tsawwassen First Nation to, and I'm quoting here from the lawsuit, seek a declaration of Aboriginal title to their traditional village of Indgenous and the surrounding lands, and to submerge lands in the Fraser River. They also seek a declaration of Aboriginal right to fish the south arm of the Fraser River for food, end quote. So, after more than a decade and a trial of 513 days, the Cowichan Nation won. The city of Richmond in October sent a letter to its residents, the ones living in the area along the Fraser River affected by this ruling. It invited them to this public hearing, and it warned that the Supreme Court had, quote, made some very important decisions which could negatively affect the title to their property. So I covered this night over at the National Post, where you can get a full account of this tense public hearing. When I say tense, I mean tense. There was yelling. Richmond Mayor Malcolm Brodie threatened to shut the entire thing down several times, and property owners mostly unleashed their fury towards Richmond elected officials. The reason they were so angry with Richmond officials is that they felt betrayed because they didn't actually know about this lawsuit until it was lost. That's right, the Cowichan Nation did not notify the homeowners on the land, nor did the province, nor did the city. So Mayor Brodie and his legal team spent the night saying that the Cowichan Nation should have done it, they should have told property owners, but the residents don't really seem to care about the legal technicality behind this. They're steaming mad that the city didn't do it. So the only one thing that was really clear at the end of this public hearing is that nothing is clear about Cowichan v. Canada. The ruling really seems to be all that anyone in the province, country, even right now, is talking about. Unlike other news stories that cycle in and out in hours or days, I think this one's going to be staying with us for a long time. It's not disappearing anytime soon. It's a ruling that, according to some, jeopardizes private property ownership in BC and possibly all of Canada. To other people, however, this is a ruling that's merely a step towards what we call reconciliation with the Indigenous persons of Canada. And to them, it's not at all a threat to private landowners inside or outside of the Cowichan area. What it comes down to then is really a legal disagreement between whether fee simple title or property ownership is able to coexist at the same time as Aboriginal title, which awards Indigenous persons right to use and occupy land. This is playing out in BC, where most of our land was never historically ceded or surrendered to the Crown in treaty negotiations. This means that this very same thing that happened in Richmond could happen in almost all of BC for almost all of our private landowners. This decision is being appealed by both the city of Richmond and the province. The city of Richmond is insisting that the only legal argument that will suffice is one that's called extinguishment, which would completely extinguish or abolish Aboriginal title. The province, meanwhile, is taking another approach and has taken another approach. As BC Attorney General Nikki Sharma told the crowd in Richmond at the public hearing this week, the province insists that they do take the concerns of property owners very seriously, debatable in my opinion, but that their legal argument is one to advance reconciliation by proving that fee simple property title is the, quote, paramount legal structure over Aboriginal title. So in other words, Richmond says that fee simple and Aboriginal title cannot coexist. The province says that they can. So it's within this context that hundreds of Canadians have now deemed themselves armchair title lawyers. We're having a lot of fun. But let's get into exactly what the residents in this area are afraid of. So the Cowichan Nation has claimed that they don't want to affect private property owners' land or rights in the area that they've been given this Aboriginal title to. So I guess we're all supposed to just take them at their word for it, I suppose. From the legal ruling, this is a quote from the judge: the Cowichan have not made a claim for return of land from non-parties referring to the private property owners, quote, and the property rights of the private landowners are not undermined, end quote. Perhaps not now, they're not. But what if the Cowichan Nation changes its mind? What happens then? So this is really the uncertainty that these residents are dealing with. At this public hearing, property owners shared their fears about renewing mortgages, the property value of their homes, the fact that they've for more than a decade been paying property taxes to a city that didn't even notify them that their title was potentially at risk, and whether they're going to be able to get home insurance going forward. And what has happened already as a result of the ruling? Well, it hit the news this week that Richmond councillor Alexa Liu was contacted by an entrepreneur whose company, which hasn't been named, was refused $100 million in financing because of the Cowichan decision. This entrepreneur is saying that they own land in the Cowichan area and had plans to build a manufacturing facility there. Their lender, National Bank, pulled the deal and allegedly cited the Cowichan ruling as the reason for doing so. So National Bank has since denied in comments to media that they've given staff any instructions or advice related to the decision. Their comments included saying that, quote, no specific directive has been given to our teams regarding this court ruling, end quote, and later that, quote, they cannot comment on specific cases for confidentiality purposes, but what we can confirm is that this is not a factor that is currently taken into account in our financing decisions, and no guidelines have been issued by the bank in this regard, end quote. So this is my thought. The bank is under no specific obligation to be perfectly honest about why they pulled financing from this business. It's like a breakup, it's not you, it's me platitude. But this being a breakup where there are lawyers and lawsuits and international media attention involved, I'm not entirely convinced that National Bank is telling the truth. And nor did they even outright claim that the Cowichan decision wasn't used in the determination to deny this specific loan. Their statement's rather vague, and it speaks more to their organizational communication and directives rather than to this specific lender's individual decision-making abilities. Would a studious lender for a major bank not sort of see the discourse around the Cowichan decision and decide of their own volition to pull the plug on this deal? It sounds entirely plausible to me. Banks obviously care about money. When they lend their money, they want to make damn sure they're going to get a return. The banks won't really be interested in nuanced legal arguments as to whether Aboriginal and fee simple title can coexist or not. Banks aren't going to put up $100 million for a project on a piece of land that's subject to ongoing legal proceedings that could, as per the City of Richmond's legal team, take upwards of another 5 years to resolve if it goes all the way to the Supreme Court of Canada, and which could end with the entrepreneur in question losing the fee simple title to their property. So there's one more example. Following this Richmond public hearing, numerous journalists recorded this now viral video with a local man who says he's lived in Richmond since 1975. He alleged that he owns a mortgaged home in the Cowichan ruling area and that his bank has already refused to renew his mortgage. So again, this isn't verified, but as far as I'm concerned, it's quite easy to believe. So the City of Richmond at the public hearing, they actually told the crowd they would like any property owners affected by the ruling, whether they can't renew a mortgage, get home insurance, anything else, to contact them. These people can potentially become interveners in the upcoming legal proceedings. So an intervener is someone who's able to provide evidence in a lawsuit without joining it as an actual party. Since private landowners, in this case, have thus far been excluded, this is a way to bring them to the table. So we'll see how many owners actually decide to sign up for this, particularly because they're feeling so spurned over their exclusion as parties in the original lawsuit. Now, okay, so all of this is happening, of course, in the context of reconciliation. The notion that Canada and Canadians owe apologies and reparations for past and even ongoing harms. So reconciliation, as most of us know, is extremely contentious right now. How much is owed? For how long? Who should feel guilty for the past? All of us? Should my children? Should they call themselves settlers or colonialists? Must I tell my young sons that they have white privilege? Or will their school do it for them without my consent? Is there a point at which we can all respectfully acknowledge our history and the terrible things that happened to Indigenous persons in Canada, but also acknowledge that at some point, it's time to move on? And that at some point, it's counterproductive to obsess over a grievance narrative that pits Canadians against each other. The settlers versus the Indigenous, the oppressors versus the forever oppressed. Reconciliation has really been twisted into this grotesque, unquestionable, and never-ending victim narrative that paints Indigenous Canadians as weak, helpless persons who we must constantly demonstrate our utmost reverence for. We do this with our land acknowledgements. We do this by not questioning the Kamloops mass graves hoax and by insisting that anyone who does is a horrible racist. We do this by providing Indigenous persons with separate phone lines and separate driving tests so they're not emotionally triggered when driving past certain locations. Yes, this is a real thing that the Insurance Corporation of British Columbia currently does for Indigenous drivers. And now apparently we also do reconciliation by literally following through on the slogan, land back. But what did we really think was going to happen after performing all of these land acknowledgements and shouting these slogans? So this legal ruling, I think Canada is starting to see, at least we're beginning to see the end of the reconciliation industry because of Cowichan v. Canada. So say what you will about people's overblown fears or their poor understanding of title law. Argue that, you know title law better than they do. We will see in time what impacts actually flow from this legal decision. We will see, in the meantime, how many property owners continue to vote for the politicians and the parties that are pushing reconciliation now that these people know exactly what could be at stake. People have a funny way of finally understanding an issue when it comes knocking on their front door. And guess what? It has. It finally has.